Hello, I'm Dominic Walker, JMW's Inside Man. My guest is Zila Lwanda. Zila is a solicitor within JMW's Employment Law Department. So the government have announced the guidelines, the rules surrounding living with COVID. These things, Zila, are long and laborious to go through, but we've got you to do that for us. And I was hoping you could sort of tell us what are the important points that employers need to know about.
Yeah, so there's four key features of the government's Living with COVID plan which affect the workplace. The first is that the legal requirement to self-isolate has been removed. So now it's advisory only for individuals who test positive for COVID-19 to stay at home and avoid contact with other people. The advice is that they can return to a normal routine after receiving 2 negative lateral flow tests on consecutive days. So employees testing positive for COVID-19 no longer have a legal obligation to self-isolate and tell their employers. The second change is that the provisions on statutory sick pay revert to their pre-pandemic position from the 24th of March. That means the right to claim from the first day of COVID-related absence has been discontinued. An individual who's sick with COVID will then only be paid from their 4th day of absence. The third change is that from the 1st of April, employers will no longer need to explicitly consider COVID-19 in their risk assessments as a health and safety requirement. And lastly, from the 1st of April, the government is no longer going to provide free universal symptomatic and asymptomatic testing for the general public. And testing will only remain for a small number of at-risk groups.
So from what you're saying, Zila, it seems to place quite a lot of onus on the employers and give them scope.
That's right. Effectively, the onus has shifted to employers to manage COVID-19 related matters. So going forward, employers have the choice to implement rules going beyond the government advice. So examples of some measures employers could maintain or introduce to achieve a safe workplace are, firstly, stipulating that COVID-19 positive or symptomatic employees work from home if possible, or self-isolate for a specified period of time. The second thing employers might choose to do is to extend company sick pay to encourage workers to stay at home if they are COVID positive or symptomatic and unable to work from home. So an important caveat on that point is that individuals who feel well enough to work will likely be ineligible for statutory sick pay and company sick pay. So if workers are required to stay at home in these circumstances, then they'll be entitled to full pay. Employers might choose to implement workplace testing. So the need to pay privately for testing will undoubtedly be a disincentive to employees to continually screen for COVID. So employers might introduce or maintain workplace testing capacity to encourage practices which will help to identify COVID-19 risks and encourage the appropriate responses.
And what are the risks for employers, Zila, and how can you help?
So the licence that's granted to employers is unlikely to be risk-free. There may be objections from employees on the basis that rules have a detrimental impact on particular members of the workforce, and those might be for reasons that relate to protected characteristics. So employers might be exposed to claims under the Equality Act. It might also be that an approach which is perceived as too permissive is subject to complaints about persisting or emergent health and safety concerns. And employees might seek to rely on protections in the Employment Rights Act.
Thank you, Zila. And if you'd like to speak to Zila and the employment team at JMW, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.